But I hear you when you talk about the fact that previously you ought to have been given notice, and that's one of the arguments of the defense, that you don't just bring a charged person, as it were. If a man, you say the man has committed an infraction on the code of conduct where he has made an anticipatory declaration or has actually falsely declared things, you notify him first to see whether he can correct it. That's the argument for the defense. I will advise that we don't get into that so that we can let the people who have earned substantial fees to do their work in court.
Just wondering though, I mean, some people will say that this could also have implications for subsequent trials. This could have implications for subsequent persons who might be appearing in courts for whatever reason, especially if they're politicians, perhaps to come and answer the things that they have done. We don't know what could throw those things up. It could be politically motivated. It could be that the agencies all of a sudden wake up and begin to do their jobs. But do you see, what influence do you see this trial having on, say, for instance, their morale?
You see, March is when you have a problem, you fix it. If the Court of Appeal, peradventure, comes to the decision that the panel was not properly constituted, then obviously they can't proceed with other matters without you fixing that problem. Now, can they fix it immediately? Perhaps not, because of the circumstances that led to this. And you see, that's what sometimes I tell prosecution, you need to be careful when you rush to prosecution. You need to be sure that all your ducks are in a row, all your T's have been crossed, all your I's have been dotted. So you ensure that when you start prosecution, you don't get these kind of hiccups. Because truly, people will throw the debt to you and try to create a hiccup so that you don't get the real merits of the matter. Now, what we're trying to say, did the Senator Saraki, the President of the Senate, do an anticipatory declaration? Did he falsely disclose assets? We have not got into that merits because the procedural things which ought to have been fixed have been challenged. Now, if the Court of Appeal, in their wisdom, decide that there's not been a proper constitution and they had no decision, then obviously all that's been done to this point becomes void ab initio. How does that affect morale? Of course, morale will be dampened because everybody will now ride on the back of that until it's fixed. Will they be fixed easily and quickly? I doubt. And that becomes a challenge. And that's been our bane as a country.
Has there been any precedence for this, say even at the level of the Court of Appeal, where you also require 3 justices at the very minimum?
It's never been a problem in the Court of Appeal because I've never seen any time the Court of Appeal having less than 3 in the quorum. They've always had it. It's either 5, 3, or 7, depending on the nature of the matter. And they've never had it. But mind you, the Court of Appeal, as it were, has a bunch of judges. There are lots of them. And they can actually move them to different divisions, as distinct from the Code of Conduct, which seems to be one panel. So the situation has you never had something that analogous to what we're having right now.
Can you move people into that tribunal to also do cases?
In tribal city, no, you can't do that except the tribunal is specially constituted for that purpose. In the Court of Appeal, you have different divisions spanning from Kaduna through to Calabar. And so nobody says you can sit in a division. Indeed, in election petitions, you constitute a different panel from any of the quorum. So you've never had that challenge where you've been short of a quorum in the Court of Appeal, as what we have right now. The Code of Conduct specially constituted tribunal, which has been appointed for that purpose. For some reason, there's been a shortfall of one person, and for some reason, it's not been filled before now. These are the things, the processes that processes need to think about. So you don't go to the middle of a battle and suddenly decide, I've run out of bullets.
And it's a logjam the way it is now. And if you look at it politically and in trying not to delve into the matter, looking at the merits of some of these things that you've just highlighted, it would seem as if the nation didn't foresee a moment like this. Because we're looking at a vacuum, or what we haven't done as a people, as a nation, to have had that kind of vacuum. How can this be remedied in the light of this, knowing that now it is already tainted in politics? Because it could also mean something else when it's not a trial that has some political coloration. What if? So shouldn't we be thinking of how to remedy that particular situation to have a full composition of those to be there?
It's not difficult to remedy it. The reason why it's been looking difficult as if now is because you're trying a senator, the president of Senate, who happens to be the body provided by a constitution that will confirm whoever you want to be a third party. That's why it looks as if it's a logjam. If not, it's not an easy thing to nominate somebody and go to that place. It's not a difficult process. But because there's self-interest, there are no law says that you can force the Senate to, as it were, confirm a person, because they can raise all sorts of reasons. It's at their discretion. Mind you, they're also representative of the people. That's why it looks like a logjam. Now, fortuitously, we need to be thinking in futuro. We need to think of things before we did it. Whoever was trying to do this should have thought this out. Wait a minute, these people will come at this. So why don't we fix this first? It's a kind of putting the horse before the gut. And so what you will now have is the challenge that to try and fix it now becomes a little bit more difficult because interests are involved.
Well, speaking about elections, the Council of State rose from their session yesterday confirming a new INEC chairman.
Great news.
Some of the headlines said
great news.
They saved Bayelsa and Kogi elections.
I've been saved.
What would have happened if they didn't have a new INEC chairman?
Well, it's just not the INEC chairman. If you read the constitution of the INEC, how it's composed, you must have a certain amount of national officers, commissioners, for you to actually have a quorum to form an election, to organize an election. A lot of them retired with Jega and the last thing, great man that I worked with. And it just makes sense to have done that. It took them quite a bit, but probably it's a very sensitive position. They're probably trying to get the right man and make sure he does right. So that singular act of achieving that saved that election, because people are challenged whatever happened in that election. That again will have been back to the same thing we're now facing this Code of Conduct Tribunal, that you didn't have enough bodies and enough parties to form a quorum to decide on how the elections in Kogi and Bayelsa will have. So that was a great move, and I think that puts that behind us right now.
Yeah, but many who also wonder, well, okay, let's see, are they going to go back to, okay, yeah, we could see the new INEC appointees, the national commissioners, but I'm hearing people say, look, we'll still have 17 more to be made, national commissioners. But this is a quorum. They can go?
Once you have the quorum, you need to look at the law. Once the appointees now are up to form a quorum, I think that's the reason why they had to get this in. Because if you didn't get this in, Kogi will have failed. They wouldn't have been able to go with Kogi. Same thing with Bayelsa. They will have challenged them. So once they have the quorum, it doesn't matter whether there's a vacancy created. You must not fill every position at every point in time if you don't write the right people. But once you've done enough people that have formed the quorum, then you can proceed with what things you have to do.
But not having the right people, or not having the entire team in place at this time, many who criticize and look, they thought that all of those persons should have been in place by now, such that you forget about this and move on to the next things.
You know, one of the things that this administration rode on to become popular was that they intended to fight corruption in all its ramifications. If you heard Bishop Kuka speak, he says that one of our greatest problems is corruption. And indeed, the president says that if we don't kill corruption, corruption will kill us. So I think trying to get the right people who are not tainted is a very difficult task. I like to believe that if he has achieved at this point in time a quorum to run with INEC, I think the critics should be a little bit more careful in being critical. As long as we have a quorum to do the job, it makes sense to have a full complement. There's no doubt about it. But sometimes picking and sifting the wheat from the chaff is sometimes very difficult if you're an authority.
In other words, as at the last time, many said, okay, well, whoever comes in as INEC chairman has got to take off and surpass what was done previously. Do you think electronic voting may be considered this time out?
One of the arguments against electronic voting, I don't know if you followed the arguments at the time, was whether it was even constitutional. If you remember, we tried to distinguish between accreditation and voting. For me, it's a case of a chicken and an egg, which comes first. We've not really quite tested that, so let me not talk about that. But it's a little bit difficult why you can actually discuss that accreditation is not part of voting. But they got away with it the other time because the law says that we are not allowed to do electronic voting. So perhaps what we need to consider right now, going forward, is that we need to clear that constitutional provision and make electronic voting possible so we don't have that argument. But there's no doubt that the concept of card reader and things associated with e-voting makes a lot more sense. This is the way to go. It's the only way to think in the future. It does take away a lot of things that work when eventually it works well. Because typically in Nigeria, they've thrown all spanners in the works to make sure that it doesn't work well. But it's the way to go. And if we can stay the course, then obviously we're in the right direction.
You know, I hate to take you back, sorry, Sulaiman, but I just can't help but ask. First of all, you already predict that this trial is going to be a long-drawn one with the CCT. But how do you also see, did you see any correlation between ministerial screening and this trial?
I'm careful not to get into that domain. You see, as a lawyer, I deal with facts. I've heard all sorts of rumors on this that Amachi's screen has been tied down to it. I've heard all sorts of that. I like not to be drawn into it because I don't have the facts to be able to debate that. But you see, if the witch cried last night...
Can you dismiss it?
If the witch cried last night and the child died the following morning, you can draw the correlation yourself.
Especially when the building collapsed.
Okay, that's an interesting answer.
Okay, very interesting. Good to have you always. Dr. Akweda is a senior advocate of Nigeria and legal practitioner. Thank you for coming on this morning.
Thank you very much, Chamberlain. Always a pleasure to be here.
All right.